Welcome to Faith and Freedom. For the next few minutes, we hope to inform, inspire, and encourage you as we discuss the legal victories and challenges to your fundamental freedoms and religious liberties. Faith and Freedom comes to you from Liberty Counsel, a civil liberties education and legal defense organization. Join us now as Matt Staver, the President and General Counsel of Liberty Counsel, explains the latest legal issues all across this country in the courtrooms of America. Liberty Counsel is winning the battle for your constitutional freedoms.
California Judge Vaughn Walker has come out of the closet and admitted that he's a practitioner of the homosexual lifestyle. Those of us who called for his recusal have now been proven right. I'm Matt Barber, Vice President of Liberty Counsel Action and Associate Dean with Liberty University School of Law. And joining me again in studio today is Shawn Akers, Dean of Liberty's Helms School of Government and Policy Analyst with Liberty Counsel. Well, Shawn, a couple of years ago, as Vaughn Walker, the case involving Proposition 8 and California protecting the institution of marriage between a man and a woman in California, the constitutional amendment that was voted and passed in that state, that very liberal state, it was rumored, the San Francisco Chronicle essentially suggested and outed the judge who was overseeing that case, Vaughn Walker, as an active homosexual. He would not comment on that, and unfortunately, the attorneys handling the case at the time did not look into that and did not do what they should have done and call for his recusal. I did call for his recusal at the time and received a great deal of grief for doing so. Now he has come out. He has said, yes, in fact, I do have a partner. I am a homosexual, showing clearly that he had a conflict of interest as he was sitting in a position to grant himself a new right, to divine a new right out of thin air that had not previously existed. So, federal law is clear on this topic. It says, for instance, that if a judge, and I've got it right here. Federal law says a judge shall disqualify himself when he knows that he has a financial or any other interest that could be substantially affected by the outcome of the proceeding. Clearly, Judge Vaughn Walker, he would be personally affected in that before he ruled, he would not be allowed to marry his partner. After he ruled, he could marry his partner. That's a definition of a conflict of interest.
Matt, I've had the great pleasure of practicing law in front of a great many very, very honorable judges. And I'll tell you, in practice, the way that they handle recusals is more than just saying, I have an actual interest. They want to avoid even the appearance of bias for the protection and for the sake of the rule of law. They always want to come out on the side where their credibility and their honor can't be questioned. In this particular case, an analogy will help clear it up, because where this dividing line is, or those that are going to say that Walker was perfectly in his right are going to say that the qualities that we're saying should have caused his recusal were innate qualities, things that he was born with and part of who he was, rather than things that he does. Now, if you look at it from the thing that he does side, it would be a little bit like having a judge who is an active gambler at the boats every weekend make the decision on whether a state should allow gambling. You wouldn't want to do that, because and the judge wouldn't want to sit in that position. If you know that he's a proponent of the thing, that he partakes in the new right, that whatever new, even if he wasn't going to go to those particular casinos, you still know that he actively participates in this action. Yeah. If you know that a judge, for instance, even with a prescription, uses medical marijuana, you probably don't want him, he probably doesn't want himself sitting ruling on a medical marijuana case on whether it should be allowed or not.
Right.
Because he's an interested party. In this particular case, this judge didn't even disclose. He wouldn't even admit. At a bare minimum, at a bare minimum, he should have disclosed the fact that he was homosexual, to say that there is at least the appearance of the potential appearance of a conflict. Now, I deny that there's any conflict, but I do want to be forthright with the court and let everybody know he didn't even go that far. In reality, Matt, The only thing that I can think of that a judge would not recuse himself in this situation is if he did want his particular set of opinions to influence the court. Otherwise, if he was truly disinterested, if he was truly a disinterested party here, a disinterested judge, he would have recused himself to make sure that whatever decision is made couldn't be challenged later.
Well, and the fact that he divined and created new rights out of whole cloth, and even went against the Ninth Circuit Court of Appeals, which had previously ruled
it's a radical decision.
That homosexual behavior is not immutable, is changeable, and therefore is not deserving of a special protected suspect minority class. The Ninth Circuit has ruled that in previous cases. He went against the Ninth Circuit and said it is an inborn characteristic against all the science to the contrary, which is overwhelming. There is no legitimate science. It's all been debunked that suggests people are born gay. Well, Shawn, but what you're saying is not simply a matter of opinion, that he, an honorable judge would recuse himself if there's even the appearance of a conflict of interest. The reality is that is a requirement, Shawn, that U.S. Code Section 455A states, quote, any justice, judge, or magistrate judge of the United States shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned. The law goes on to say that a judge, when a judge has a personal bias or prejudice concerning a party or personal knowledge of disputed evidentiary facts concerning the proceeding, he should recuse himself. This is the textbook instance, Judge Vaughn Walker, a practitioner of homosexuality, hiding that fact from the public, clearly a conflict of interest, but at the very least, the appearance of a conflict of interest. Under federal law, he should have recused himself. He's now retired, so he can't really be sanctioned, or there can't be any real blowback on him personally. But this is very unfortunate that he engaged in this judicial activism clearly out of a personal bias, which he held because of his lifestyle.
Matt, we're in that place where judicial activism is literally taken on the appearance of the 1960s. I mean, you can almost envision the judge sitting behind the bench with a Prop 8 related T-shirt on, explaining to the members of the media watching the proceedings how he's going to rule. This is not the way courts should be run. When we talk about the rule of law, what we mean is that man is not tinkering with it. We mean that it's going to come out the same for everybody all the time. The judge simply should have recused himself.
Well, Shawn, I've had people contact me and say, well, using your logic, a heterosexual judge would have to recuse himself. That, of course, is a complete red herring. Heterosexual judges sitting on the bench are simply acknowledging the reality of law as it is and has always been. They are not trying to radically redefine the institution of marriage and don't have a vested interest in the radical redefinition of the institution of marriage. So that there's not a bias there. There's not that doesn't apply. So that's an inaccurate comparison.
But Matt, even if you take their logic, even if it was something innate, if you had a red-headed judge sitting for a law that was providing special benefits for all red-headed people, he would need to recuse himself, even though it was innate.
If for only the appearance of a conflict.
And as you pointed out, even if he doesn't plan on taking advantage of it, whether he does or not, he's going to materially create a right for himself. If he's going to do this, if he's going to do something that affects him particularly this way, it creates at a minimum the appearance of a conflict of interest.
Well, the good news is, Shawn, that I think certainly even in the Ninth Circuit Court of Appeals, Judge Vaughn Walker went against their previous rulings relative to, so-called sexual orientation and so forth, to the degree that I don't see how they don't send it back to them. The Ninth Circuit, of course, is the most liberal circuit in the land, so they may be looking for a reason to get this thing through. But ultimately, I believe this will be decided at the Supreme Court, and Judge Vaughn Walker's judicial activism hopefully will be undone at that point. Justice Kennedy is largely believed to be the swing vote. He tends not to side with a majority on instances so radical as to redefine marriage. That's the good news. We will have to see. Continue to pray for the outcome of the Proposition 8 trial as it makes its way through the courts and to the Supreme Court. Go to lc.org to learn how you can become part of our mission, or give us a call at 1-800-671-1776. Join with Liberty Counsel as we fight to save America.
You have been listening to Matt Staver of Liberty Counsel. Our hope is to encourage and inspire you to stand up for your faith, family, and freedoms. We can accomplish a lot when we work together. Get informed and get involved today. Sign up for our free monthly newsletter, The Liberator. We will send it out to you free of charge. Stay informed with our Liberty Alert email update. Just click on the website at www.lc.org or call us at 1-800-671-1776. Tune in next time to learn more about your rights right here on Faith and Freedom.